Well, good afternoon, everyone, and welcome to the Williamson-Barwick webinar on what if your employee refuses to be vaccinated. My name's Adrian Barwick. I'm the Solicitor Director of Williamson-Barwick, and I'm here today with my colleague in the law, Lucinda Frantz, Senior Solicitor. And first up, I'd like to acknowledge that this webinar is being broadcast from the traditional lands of the Gadigal people of the Eora Nation, and we pay our respects to their elders, past, present and emerging. Well, today in New South Wales, the 15th of December, is something of a red letter day because the general restrictions imposed by COVID are being relaxed, and with 93.2% of the eligible population above 16 fully vaccinated, there's some hope that many businesses will be able to reopen. But at the same time, of course, we need to be realistic because the Omicron variant of COVID is teaching us that we've got to expect the unexpected, and there may yet be further bumps along what will be a long road. So firstly, what we're going to cover today, the information we're going to provide to you is general in nature. It's not intended as specific legal advice for your context. If you require particular legal advice, we'd encourage you to reach out to your advisors or to us. We'd be very happy to help. Today, we're going to confine ourselves to the context of employees who are not subject to a public health order in their employment to be vaccinated. Otherwise, this topic would be far too broad for us to cover everything. And so whilst the focus of the presentation is largely on the New South Wales context, much of what we will discuss has national implications throughout Australia. We're going to cover three things. Firstly, we're going to cover whether employees can let their unvaccinated employees work. Second, we're going to deal with whether employers can mandate that their employees be vaccinated against COVID-19. And then thirdly, we're going to give an outline of the options available for what to do if you're an employer and your employees refuse a direction to be vaccinated. Now, so that's what we're going to cover in terms of the content in the first half. In the second half, more or less, we're going to open it up for a Q&A session. Well, now, let's just firstly set the scene in terms of the context, the legal context, if you like, that we find ourselves in at the moment. So presently, none of the industrial tribunals, including the Fair Work Commission, have handed down an unfair dismissal decision, specifically in the context of an employee who's refused to be vaccinated. But there has been a whole lot of litigation that's COVID related. In particular, there have been a number of unsuccessful challenges through state Supreme Courts, including here in New South Wales, against the public health orders. The most noteworthy example is Kazam and Hazard, which was a decision of His Honour Justice Beach Jones of the Supreme Court of New South Wales. He determined that a requirement under the PHO to be vaccinated did not infringe on a person's right to bodily autonomy and integrity, because each employee has a choice as to whether or not to be vaccinated. So those challenges against the PHO, the public health orders, I should say, have been unsuccessful. Even though the court in that case accepted that the effect of the PHO is an encouraging effect or even a coercive effect in one sense, they did not authorise vaccination of a person without the person's consent. Workers can still make an informed choice to refuse to be vaccinated. There were various other arguments raised by the plaintiffs in those cases around sort of, I suppose, human rights or legal rights arguments that failed. The plaintiffs appealed that decision, but recently the Court of Appeal dismissed that appeal. That was on the 8th of December, and they ordered the plaintiffs to pay the legal costs. So there's been some other similar cases in other jurisdictions that have also got nowhere to date in terms of challenging public health orders and mandatory vaccination. Now I'm going to hand over to Lucinda to discuss whether employers can let their unvaccinated employees work. So Lucinda, over to you.
Thanks so much, Adrian. The general principle, our starting point, is that if there is no public health order prohibiting unvaccinated employees from working, they can work. However, where there's a public health order which prohibits unvaccinated workers from attending work, for example, the public health orders covering school and childcare staff, healthcare workers, persons working at aged care facilities, and disability support workers, they cannot attend work for the duration of that public health order. The public health orders all tend to apply for a maximum of a 90-day period. There are specific rules which have applied in recent times, but they ended yesterday. Those rules prevented unvaccinated persons from working in certain premises, for example, in hospitality, hairdressers, spas, other higher risk premises. So those restrictions have all ended. Now we're moving to a new realm as of today. It remains necessary to continuously review whether there are any general restrictions in public health orders which apply to certain workplaces. But as of today, the general public health order has been updated to remove those exclusions. Further, the rules which did require unvaccinated employees to work from home, unless it's not reasonably practicable to do so, they also ended yesterday. So this leaves employers with a general discretion about whether to allow their employees to work from home or not. So we can move now to this consideration of what is the best thing to do. Allowing unvaccinated employees to attend work is tantamount to requiring your vaccinated employees and others with whom they have contact to be exposed to vaccinated persons. Importantly, it also involves exposing your unvaccinated employees to workplace risks of contracting SARS-CoV-2, which causes a disease, COVID-19. Now, since unvaccinated employees are at significantly greater risk of serious illness if they contract COVID, this is an important risk to assess. We'll wait and see where we end up, as Adrian mentioned, with the Omicron variant, but early data, again, we're not health experts here, but early data does indicate it's more transmissible. While according to infectious diseases experts, for example, Dr. Peter Collinghan, who is ANU's Professor of Infectious Diseases in today's Sydney Morning Herald, he's said that there is no convincing evidence so far that it causes more serious illness than Delta. So many of our clients have told us there's quite a degree of hesitancy amongst their vaccinated staff in relation to risks of being exposed to their unvaccinated colleagues at work. In particular, those who've got children under 12 who can't yet be vaccinated, they're worried. Consequently, for all these reasons, we need to consider employer duties and obligations under work health and safety legislation. In summary, persons conducting a business, workers and officers have a non-delegable duty of care to ensure, as far as reasonably practicable, the health and safety of workers while at work. Clearly, this includes the risk of contracting COVID at work. Workers must also take reasonable steps to help to stop the spread of COVID. The way forward to resolve these complex issues involves taking the critical step of undertaking a risk assessment, which specifically considers each category of employee. It involves identifying, assessing, controlling risks arising from the presence of unvaccinated people in your workplace. The risk assessment involves a careful consideration of whether there are or are not appropriate control measures available to discharge the employer's work health and safety obligations to ensure the safety of workers. So it will involve consideration of the myriad of different measures we've become quite familiar with, including physical distancing, hygiene, cleaning practices. It'll involve consideration of other control measures like mask wearing and also rapid antigen testing, along with, obviously, vaccination. Now, the result of the risk assessment will go in one of two different directions. If as a result of your risk assessment, you decide you cannot implement effective control measures to mitigate the risks arising from having unvaccinated workers in the workplace, you may decide unvaccinated workers are not to currently enter the workplace. You are legally entitled to make that decision. But as we'll discuss shortly, this may become quite relevant when deciding whether mandating vaccination is the right way forward for your workplace. Now, in the situation of deciding that the unvaccinated persons are not to attend work currently, you can't legally stand them down under Section 524 of the Fair Work Act because there's no work stoppage. You can close the office to unvaccinated employees as a temporary precautionary measure to mitigate risks in your workplace. And if duties can be performed at home, they can continue performing duties at home. But if duties can't be performed from home, then you won't have an entitlement to stand them down. So in usual circumstances, you'd need to continue to pay employees. So this leads us to our next topic of whether employers can mandate that their employees must be vaccinated. So Adrian is going to discuss whether a direction to be vaccinated fulfills the necessary requirements for it to be a lawful and reasonable direction. And then I'll discuss the extent to which consultation is required to ensure the direction is reasonable, along with a few practical how-to tips on effectively implementing a mandatory vaccination policy. So over to you, Adrian.
Thanks, Lucinda. So I guess the starting point is to note that many employees will have a written employment contract, and there may be an express term in that employment contract that states something to the effect that they must obey the lawful and reasonable directions, or at least the directions of their employer. But even in the absence of an express term, the common law in Australia recognises an implied term, an implied duty, if you like, on the part of an employee to obey the lawful and reasonable directions of their employer. So what does that mean? Well, just focusing in on this question of lawfulness first. So an employee is expected to obey instructions that are incidental to their work, but not directions that go beyond the nature of their work. So, for example, if a manager ordered an employee to dig out his swimming pool on the weekend, had nothing to do with work, that wouldn't be within the scope of the employment, would it? So a direction is lawful if it relates to the person's employment and involves no illegality. So whether a direction is lawful is a question of fact that you've got to work out in the particular factual context of that person's employment. But the recent decision of the full bench of the Fair Work Commission in CFMEU and Mount Arthur Coal, it's a decision of 3 December, shed some helpful light on the approach that the Fair Work Commission, at least, is likely to take on this issue of lawfulness of a direction for mandatory vaccination. So the Fair Work Commission's full bench concluded that BHP's vaccination requirement for site access, in other words, you had to be vaccinated to come on site, was a lawful direction because it fell within the scope of the employment, and secondly, it involved no illegality. There's nothing illegal about getting vaccinated. And it's our firm view that mandating vaccination for employees who work in a shared workspace is a lawful direction, even if that's an outdoor workspace such as the one at Mount Arthur coal mine. Now, in that decision, the Commission decided that there's a range of factors that get weighed up in favour of determining that the site access requirement for mandatory vaccination was reasonable, although as Lucinda will discuss shortly, the failure to consult with the staff meant that ultimately the policy was held not to be reasonable. That's another story. Well, by way of brief factual background to this matter, so it was raised as an industrial dispute to the Commission. It was not an unfair dismissal claim. The dispute involved a direction that all workers at the BHP site must be vaccinated with at least a single dose of vaccine by 10 November and to be fully vaccinated by 31 January 2022. Now, the union, representing about some 700 workers on site, notified the Commission of a dispute under the dispute resolution procedure under their enterprise agreement. And in the decision, the Fair Work Commission full bench stated that reasonableness of a direction is a question of fact, having regard to all the circumstances, and this may depend upon the particular type of employment. So I guess what I'm saying here is that it's not a one rule for all type of scenario. Significantly, what the Commission also stated is that to establish that a direction is reasonable, it's not necessary to show that the direction is the preferable or the most appropriate or the only course available to the employer, or necessarily even in accordance with best practice of the parties. It's a question of it just simply being reasonable. Now, so the Commission considered the following factors, provided a strong case in favour of determining that the site access requirement was reasonable. So there's these. So firstly, it was directed at ensuring the health and safety of workers, so viewed through the rubric of work health and safety obligations. Second, it had a logical and understandable basis to it. Third, it was reasonable and proportionate to the risks that COVID-19 exposed to the workforce. Fourth, it was developed having regard to the particular circumstances and requirements of the mine, including that mine workers can't work from home and would necessarily come into regular contact with others while working. Fifth, the time for commencement was determined by reference to the circumstances in New South Wales and the local area at the relevant time. And finally, its implementation occurred after Mount Arthur had spent considerable time encouraging vaccination on a voluntary basis and setting up a vaccination hub. So the reasoning in this decision suggests that provided an employer has conducted a risk assessment, has a reasonable basis to require employees to work in a shared workspace, and has consulted in compliance with work health and safety legislation and any applicable industrial instrument, then an employer's mandatory vaccination policy will be held to be a lawful and reasonable direction. Now, Lucinda made mention of risk assessments, and I mention them again now since undertaking a risk assessment is a critical step when determining whether a direction would be reasonable to mandate vaccinations. Now, since employers have a non-delegable duty under work health and safety, that means they can't pass the duty off to someone else, it's incumbent upon the employer to identify the risks, to eliminate them where possible, and if they can't be eliminated, to then mitigate those risks as far as is reasonably practicable. And a risk assessment is a critical tool to enable an employer to do that and to discharge that obligation under the Work Health and Safety Act. Well, now, a risk assessment needs to be done for each category of employee too, because of course some employees might be outdoors, some might be in an office environment. Safe Work Australia has issued some guidance in terms of the factors that you might consider when undertaking a risk assessment. So they can include, for example, advice from the health authorities, the nature of the work environment, proximity of workers within the workplace, how close are they or can they be socially distanced, the extent of interaction with the public, and vulnerability of workers and customers or other persons who are coming into the workplace. Well, now, Lucinda, over to you. You're going to talk about consultation.
Yes.
Yeah.
Yes, thank you so much, Adrian. As noted by Adrian in the recent Mount Arthur Coal decision, BHP's failure to consult prior to implementing their vaccination policy meant the Fair Work Commission decided the policy was not reasonable and could not be enforced. This was because the consultation obligations under sections 47 to 49 of the Work Health and Safety Act were enlivened. BHP was required under section 47(1) to consult so far as reasonably practicable with workers at the site or workers who were likely to be affected by the requirement and any mine health and safety representatives. BHP unfortunately did not do so. They didn't give an opportunity for employees to contribute their views, and there were no genuine attempts to consult with health and safety representatives. Since there's a real risk this case will be relied upon by employees who are not in favour of mandatory vaccinations, in a context where much of the other case law is not in their favour, it's particularly important that employers comply with consultation obligations. Most critically, the consultation needs to be before finalising and promulgating the policy. It can't be an afterthought. There may also be other consultation obligations in an applicable award or industrial agreement. Frequently, these obligations are at a different point in time, being after a definite decision has been made. But here we're talking about the obligations under the Work Health and Safety legislation. So the consultation, and this is the Fair Work Commission's words, must be meaningful. This will vary according to the nature and circumstances of the situation. So we generally recommend that consultation involves a number of steps. Firstly, providing a copy of the proposed policy to workers and your Health and Safety Committee for their comment and feedback. Setting out the background and some context for the proposed policy, including the legal basis for it. There needs to also be a reasonably detailed disclosure and engagement about the hazards identified by the organisation and what control measures have been considered to mitigate such risks. This is usually done by providing the organisation's risk assessment, which underpins the proposed policy. There needs to be a focus on how risks related to COVID are to be managed in the workplace, not just through vaccination, but through a range of other measures. Importantly, workers and the Health and Safety Committee need to be given the opportunity to contribute in some way, allowing them a genuine opportunity to persuade the decision maker to adopt a different course of action. Now, I note there just the requirement that it's a genuine opportunity. You need to take into account views of workers. However, importantly, adequate consultation doesn't require those consulted with to actually agree with the course of action that the organisation is taking or to endorse it. They don't have a power of veto. They have an entitlement to be consulted. After these steps have been undertaken, you may well find you make some changes to your proposed policy as a result of the consultation. That can be helpful because it demonstrates the reality of your consultation and shows it was meaningful. You'd then generally recirculate the amended policy and ultimately advise workers of the outcome. Now, it's important just to consider what the consultation is not about. The consultation is not about the effectiveness of vaccines generally. It's not about whether people are comfortable generally returning to the workplace. However, discussing such matters is often very important from an HR perspective to understand employee sentiment and instill confidence in what the organisation is doing to manage risks. Consultation will look different in different workplaces. The full bench recognised this in the Mount Arthur Cole decision by specifically noting, and it almost looks like they had a crystal ball here, that if there was a surge in COVID cases, increasing the risk of transmission, or, wait for it, another crystal ball moment, a new more virulent variant became prevalent, such circumstances may warrant a truncated consultation process. They also noted the extent of consultation will be impacted by the urgency of the situation. So this means organisations may wish to seek specific advice particular to their situation and their workplace if they're looking to mandate vaccination. Now, I'm just going to briefly cover off on a few tips for implementing a mandatory vaccination policy. I've got 7 brief tips for today. Where time permits, it's preferable to strongly encourage voluntary vaccination as a first step, if not done already. Many of our clients choose to use an anonymous survey to gauge employee sentiment, concerns, the level of vaccination, and to ensure that they are sensitive to their employees' concerns and personal situations should they wish to anonymously disclose them. Second step, consider the information that will be included in the consultation process. As I mentioned previously, a draft mandatory vaccination policy will often be circulated along with the risk assessment. You may choose to circulate aggregated vaccination rates, which have been provided via a staff survey, and obviously the reasons for the policy. Third, have a transparent timeline setting in place the process of consultation. Fourth, consider privacy laws. I'm not going to go into great detail today about privacy laws. Again, that could be another presentation in itself, but the fundamental requirement is that in most instances, an organisation needs to either implement or update its privacy policy if they don't yet have one, because privacy laws apply generally to most organisations to the collection of information about an employee's health. This includes information about their vaccination status. So it's also best just to minimise the amount of health information that you collect from employees and ensure that it is securely handled once collected. Fifth, support affected employees who may be very anxious and stressed about the potential for such a policy, but do direct them to their GP or official government health information where their concerns are more medical. Sixth, take employee feedback on board. May result in an improvement to your proposed policy before finalising it and promulgating it to employees. Once it's implemented, you may well need to regularly review the policy, and if there are significant changes to the policy, this may necessitate further consultation. Now I'll hand over to Adrian to discuss what to do when your employees refuse to be vaccinated.
Thanks, Lucinda. And this is sort of really the pointy, uncomfortable end and the last part of our content before we move into Q&A. So let's work on these assumptions for the purpose of this part of the discussion, that you've introduced a mandatory vaccination policy after having gone through a risk assessment and consultation process. You've now implemented the policy. You've provided a direction, ideally in writing, to the staff to comply with the policy. What we want is for the policy to be clear in terms of setting out the reasons for the vaccination requirement, the dates by which they need to have their first and second doses, and also, for that matter, the evidence requirements to satisfy you as the employer that they have in fact been vaccinated against COVID-19, or alternatively, that they have a valid medical exemption. So let's work on those assumptions. What then if an employee refuses or fails to comply with the direction? Well, it's worth noting that the legal position is that a failure or refusal by an employee to comply with a lawful and reasonable direction, particularly in a repeated fashion, will be a serious breach of their contractual obligations. It would be an act of serious misconduct. And the law permits that in circumstances where an employee commits a serious breach or engages in some sort of act of serious misconduct, that the employer is entitled to summarily dismiss the employee, that is to say without notice or payment in lieu of notice. Now, given that the most common remedy that an employee who's dismissed for refusing to be vaccinated is likely to pursue is going to be an unfair dismissal application, it's helpful to look at this through the criteria, the factors that the Fair Work Commission considers in an unfair dismissal application. And the most important one, of course, is whether the employer has a valid reason for the dismissal. Now, that might be a reason that relates to their conduct, which is to say their serious misconduct in failing or refusing to comply with a direction. But it might also be because they lack the capacity to undertake the employment. And what I mean by that is they lack the capacity to undertake an inherent requirement of their employment, namely to carry out the employment in a manner that is without undue risk to their own health and safety and to that of others. Well then, what do you do then at that juncture? So I want to give you a couple of options here. Let's say the soft option and the hard option. So just starting with the soft option first. And that might be, in the first instance, suspending the employee with their normal pay and inviting the employee or giving them an opportunity to remediate their breach, giving them an opportunity to reconsider and to comply with the direction. And if they do, great, they can be returned to duty. If they don't, however, then it may be the next step may be a show cause process whereby the employer gives the employee a letter stating that the employer is considering terminating their employment due to their serious misconduct or their lack of capacity to undertake the employment safely, and inviting the employee to exercise an opportunity to respond to that. And then, subject to considering their response, moving to dismissal. So that's one option, and obviously there's a number of incidents of procedural fairness that you'll need to think about, particular to your context and in obedience to any other policies or provisions in your enterprise agreement that might apply in your workplace. The harder option, though, may be that in circumstances where an employee is refusing to comply with the direction and unable to perform the employment due to their failure to comply with the direction and to be able to perform the work safely, is that you might invoke the principle of the work wages bargain, which is to say that in circumstances where an employee is not ready, willing and able to perform the employment, the employer is entitled to withhold wages because those valuable promises that are normally exchanged and relied upon, namely the promise to work and the promise to pay by the employer, well, in that case, the employee is not upholding their part of the work wages bargain. Now, consideration would need to be given to the particular industrial and legal context of the employment and whether that might constitute a breach of an instrument. But it is certainly a legally available option, and that might afford the employee another opportunity to reconsider their conduct and comply with the direction, but failing that, a show cause process that moves to the termination of their employment. That about brings an end to the content for our discussion. So I think now's probably a good time to field some questions.
So we've got some questions that have come in already during the presentation. So perhaps if people would like to just post their questions now as suits them in the chat, that would be fabulous. We had one question here about booster shots. And the question was, how do we address booster shots in the vaccination policy? And we haven't gone into great detail today about the precise content of your vaccination policy, but we've been busy drafting such templates and modifying them for our clients. And generally we address the obligation of booster shots within the policy that employees are required to maintain their vaccination status via booster shots in accordance with government recommendations. And we include that requirement within the vaccination policy. Is there anything you wanted to add?
Yeah, I think if your current vaccination policy doesn't expressly accommodate boosters, it might be a question of consulting further with your work health and safety reps and committee and the staff about a variation to the policy. But I would have thought ultimately that it would be a very reasonable direction to implement.
Now we've got another question about, can we require new employees to be vaccinated? Would you like to answer that one, Adrian?
And in fact, it's interesting, this question, because I have noticed that some people have misunderstood the basis for the direction for mandatory vaccination and described it as a condition of employment. But in fact, what we've been talking about this afternoon is giving a direction, not a condition of employment. So a condition of employment is obviously where employment or ongoing employment is conditional upon the employee meeting a particular requirement. And it's perfectly lawful for your new employees to have an express condition in writing in the employment agreement that that the offer of employment and acceptance and commencement and ongoing employment with the employer is subject to the person being fully vaccinated against COVID-19 and, of course, complying with the employer's policy relating to mandatory vaccination. And in many ways, that's going to be the easier solution moving forward because there's not going to be any consultation required there. It will be a condition, a written, express condition of the employment agreement, and the employment's put on a take it or leave it basis subject to that condition.
Absolutely. And when we've been drafting such provisions for clients, we also include in there the obligation that people maintain their vaccination status in terms of booster shots. And that's obviously become quite pertinent now as we're moving into booster shot territory with people who are now 5 months since their second vaccination. Now, the fairly tricky question of what if a vaccinated staff member point blank refuses to work with unvaccinated staff? Would you like to? Or I'm happy to start on that one.
I took the last one, so why don't you take this one? I know you've given this some thought.
I'll take this one. I have given this some thought, and there has been some consideration of this, and we've already been advising clients on this in a different space over the last nearly year and a half, we'll say. Now, a vaccinated employee can only refuse to undertake work if they have valid grounds under work health and safety legislation. And that is if they have a reasonable concern that carrying out the work would expose them to a serious risk to their health or safety, or an imminent or immediate exposure to a hazard. This may or may not be established in the particular situation, and you may end up with a stalemate. If an employee point blank refuses to attend for work, then obviously hear their reasons and see whether there are appropriate control measures that you can put in place which would make that person feel comfortable with returning to the workplace. It might involve a change to seating plans, for example. There might be some very simple measures that can avoid this stalemate. However, if you remain in the stalemate, then you need to consider whether a direction to attend work is lawful and reasonable. And you'll have to take into account individual factors, including the vaccinated employees' health or that of their family members, for example, to whom they would be likely to transmit an infection, because no one wants to take an infection home from work. You'd have to look at the latest health advice about transmissibility and also consider whether the employee could in fact properly perform their work from home. What if you're still at a stalemate situation? If the situation can't be resolved, then you'd need to look at arranging a visit from a safe work inspector in order to break the impasse, and that person would be able to basically indicate, and I suppose that you'd probably call it certify, that the organisation is complying with its legislative obligations to provide a safe workplace. And that gives you a way of bringing in an independent person and a way of moving forwards. But hopefully you're not going to get to that point and it can be resolved without that step. But it's probably better that the employer does that rather than waiting for their employee to instead lodge a complaint or proceed on some form of stress leave or the like.
Yeah, I think there's also a critical communication piece there with the employee who's raised the objection or concern about working with unvaccinated staff. And that's perhaps an educational piece around explaining that what the employer has as a duty under the work health and safety law is to eliminate a risk if possible, but if that risk can't be eliminated, to do what's reasonably practicable to mitigate that risk, and then to explain to the employee how it is that, and share a risk assessment with them and so forth, how it is that the employer is sought to mitigate those risks. Because of course, one of the things that we recognised through this pandemic is that subject to those employees who can work from home 100% of the time and will never come in, you can't really eliminate the risk of COVID-19 in the workplace. It's a question of mitigating the risk.
Absolutely, absolutely. Now we've got a question in relation to other sorts of vaccination and whether a view on vaccination for COVID might have a bearing on whether an employer requires other types of vaccination. That might be something that we might be better off addressing privately, I think, that question.
Yeah, I guess the one comment I would make there is that getting back to what we were talking about with what constitutes a lawful and reasonable direction, if the employer wanted to impose a requirement for some other sort of vaccination, it's going to need to relate to the employment, and it's not going to, it can't go beyond the scope of that, and it's going to need to meet all those tests of reasonableness and so forth. There are certainly other settings, in particular employment settings such as health and aged care.
Frontline healthcare workers have, for a very long time, had a lot of obligations in relation to vaccination. And it actually raises the very relevant question, which may well come up next year. Again, I don't want to do any crystal ball experiences here, with the flu. The regular influenza, because there is a case which was decided this year, the Auscare case, which involved an unfair dismissal case where a worker was required by her employer to have an influenza vaccination, which she decided not to have. And ultimately it was held that the employer's direction to have an influenza vaccination was reasonable. I gather that influenza hasn't been particularly relevant in 2021, but as we move to more of an open environment, there are some health experts out there expecting that we may well have a a rise in influenza in 2022, and it may be that in 2022 employers are looking at considerations of whether to, in addition to mandate COVID, to also mandate influenza vaccinations. So it may well come up as well. Now, further questions that we've got here. What about if our unvaccinated staff want to continue working exclusively from home? Can we allow them to do that?
Yeah, and there's the tricky thing. We've got a lot of feedback from our employer clients who, of course, during the lockdowns had no choice other than to allow and enable many of their staff to work from home for a prolonged period, and demonstrating into the bargain that it can be done. If you've got an employee, though, who is now refusing vaccination and saying, well, I think I can work from home, well, it's probably worth doing that assessment and figuring out whether they can undertake the inherent requirements of their employment from the home environment. Bear in mind, of course, that there could be a range of scenarios where you might need them to come into contact with other staff, with customers or clients or other persons, whether that's coming into the workplace for training, meetings and so forth. So I think you'd need to think broadly about whether they really can undertake their employment in that way in the long term.
Absolutely, absolutely. There was a question earlier at the very beginning which was relating to consultation obligations of where we have our employees covered by a public health order and we are, however, wanting to mandate vaccination since we work with vulnerable clients. Do we need to go through the same consultation process to develop a policy as we would if there was no public health order? That's a brilliant question. And the Fair Work Commission touched upon this, but they weren't called upon to consider it in the BHP decision. And they certainly, there are strong indications that there is no requirement for as extensive consultation where there's already a public health order in place. However, there's no suggestion that you're entirely excused from consultation. So we'd be more than happy to help with a private discussion about what that might look like in order to have some form of meaningful consultation where you've got a public health order in place, because you're probably mindful about the expiry date of such a public health order, and we never quite know whether one public health order is going to be replaced by another one on its expiry after 90 days. And so it's very forward-looking to look at what will happen, for example, on 30 January when the public health order in relation to disability support workers is due to expire. If we have persons, say, on a prolonged period of authorised absence, say they're on parental leave, are they going to be welcome to return to our workplace come 1 February unvaccinated, or do we wish to implement a mandatory vaccination policy which will provide that protection after that date? So some consultation, yes. Certainly circulation of a draft policy and an opportunity to give feedback, and certainly engagement with health and safety representatives, I think would be the minimum there, along with disclosure of your risk assessment. We're seeing time and time again that employees who are not in favour of vaccination are seeking recourse through various online forums and the like as to which avenues they can pursue. And we are with great frequency seeing requests for risk assessments. It's preferable to be on the front foot there and to be engaging by the provision of the risk assessment. It's not a secret what's in your risk assessment. It's probably your best friend here to support the decisions that you're making as being in the interests of everyone's health and safety. Yeah. Anything?
Yeah, no, I think I'd be on board with undertaking consultation to introduce an organisational policy, even if you're subject to a public health order. And there's a range of matters that that consultation and policy process could cover that might go even a bit beyond the narrow confines of the public health order itself. Yeah.
Now, another question which I was asked beforehand, what if employees are absent long-term on workers' compensation or parental leave and we're mandating vaccination for them? What happens to those employees? I'll hand that one to you.
Yeah, well, of course, it's worth noting that where you have an employee on a period of authorised leave, particularly long-term leave, such as parental leave, or for that matter, if they're unfit for work and absent on workers' compensation, then in most circumstances, an employer is going to have very limited legal capacity to give a direction to the employee because they're not on duty, they're on leave. And so I think what I would be recommending in that situation is that you look at the employee's individual circumstances, and it may be that you'll need to tailor the direction to meet their particular circumstances. Say, for example, an employee is on parental leave and isn't due to return for another 6 months. The immediate need for them to be vaccinated is not really there, but you may need to mould the direction and reset the deadlines for that person, and obviously communicate with them as required with your consultation obligations during the period of their parental leave.
Great. And then another question here about what to do with employees who have a medical exemption. And I'm happy to address that one. Well, if a public health order applies, it will usually specify what is a genuine medical exemption, and there's a particular form of certificate that needs to be completed, and that is very, very specific. And there's been a lot in the media as doctors have been challenged by persons seeking to have them complete such medical certificates in a context where the doctor and the patient don't share the same views. And that's been quite helpful to have that particular form of medical certificate. So if there's no public health order, then what we need to do is have a look at the vaccination policy. And when we prepare a vaccination policy, it usually sets out a procedure and sets out details of what constitutes a valid medical exemption. And there's normally a process of consideration of such documentation. So a medical certificate which identifies, say, a fear of needles, or a general recommendation, this is what we're seeing a little bit of now, a recommendation that an employee waits for another vaccine, such as I'm waiting for Novavax until it's approved, without any detailed medical explanation of why that is necessary for the employee's health. That's unlikely to be a genuine medical exemption. It doesn't mean you're not going to consider it, but you don't need to view it as being a genuine medical exemption. So we recommend undertaking a risk assessment and consultation process in a situation where you have accepted that the person has a valid medical exemption, which means they can't currently be vaccinated against COVID. That might involve considering other measures, such as having the employee work from home for a period of time, or considering some other measures which may or may not be appropriate for your workplace, such as rapid antigen testing, which is very much a developing area and becoming quite an option as a control in the workplace. So there'll be situations where a person with a valid medical exemption can be accommodated, and we would encourage our clients to really jump through, really work through any possibilities, work through very thoroughly whether there are appropriate control measures that can be in place to accommodate a person who has a valid medical exemption. But there may be some situations where the person can't, in fact, continue in their current role unless they are vaccinated. These situations need to be considered on a case-by-case basis, and in particular taking into account whether the employee has any rights under relevant anti-discrimination legislation because they have a particular illness or disability. The mere fact of vaccination, of not being vaccinated, isn't grounds for potential direct discrimination against employee, but there may be indirect discrimination arising from some underlying medical condition, which is the reason they can't be vaccinated. My understanding is at the moment quite a few of the employees who can't be vaccinated have in fact had COVID, and that is why there's a temporary period of time when they can't be vaccinated against COVID. And in such situations where that's only going to be a temporary exemption, then we would certainly encourage employers to to bear with them for that period of time and find a way forward so that ultimately they will be vaccinated and return to their normal duties.
Yeah. Well, we've probably about reached the end of our time.
I think we have, yes,
for today.
that's great.
It's probably worth making a couple of points in summary, I think. So I guess one of the probably the key takeaway message today is that in the vast majority of circumstances, a mandatory vaccination direction for your staff will be a lawful and reasonable direction. So that's a really key takeaway message. Consultation, what would we say in summary about that?
Meaningful. Meaningful is the key word of the day, and it may well be tailored to your organisation, and it may well be tailored to the urgency of the particular situation which you're facing.
Yeah. Well, look, thanks so much for your time today. And look, can we encourage you to reach out to us afterwards if you've got any other questions or want to follow up with issues that are relevant to your particular context. We'd love to hear from you. We're here to help. And we hope you have a really good afternoon. Thanks very much.
And also, we will be circulating a copy of the webinar.
Yes, thank you. Thanks for reminding me, Lucinda. I was meant to say that.
That's okay.
So yes, we will circulate a copy of the webinar too so that you've got that content. Good afternoon.
Thanks so much.